Welcome. Welcome to the Emily Davis Marquee at Girton College for our 150th anniversary festivities. As I hope you're aware, you're in the Women in Law panel. If anybody's here who doesn't want to be, please feel free to exit now. If you don't mind, I'll just spend a few moments explaining some of the general housekeeping notices which I'm required to do. So there is actually no planned fire drill today, so should there be a need to leave, do leave via the nearest exit. Should you require any toilets, they're outside the marquee, just outside here. And the assembly point, should there be a fire alarm, is the croquet lawn, which is in that direction, beyond the maintenance sheds. So if I start off by introducing myself, my name's Karen Lee. I'm actually the Vice-Mistress currently at Girton College, but I also read law here. And I obviously haven't reached the distinguished heights of the panellists, but I'm absolutely thrilled that Dame Rosalyn, Lady Hale and Lady Arden have agreed to come and be part of this law panel. If I just give you some brief introductions, I think you probably are aware of who they are and what they do and their achievements, but I'll just summarise them if I may. So as I think I mentioned, all three read law at Girton College. And Baroness Hale of Richmond, before becoming a full judge in 1994, she was an academic lawyer and a law reformer, and she was actually the first woman to be appointed a member of the Law Commission in 1984. She became the first woman justice of the UK Supreme Court in 2009 and was appointed Deputy President in 2013 and then President in 2017. And she was appointed Visitor of Girton College in 2004. Dame Rosalyn Higgins has held chairs in international law at Kent University and the London School of Economics, as well as many other senior positions. She served on the International Court of Justice from 1995 until 2009, was its first woman judge, and was elected president by her fellow judges in 2006. And Dame Rosalyn was also the legal advisor to the Chilcot inquiry on Iraq. Lady Arden started as a judge in the High Court's Chancery Division in 1993 and was appointed to the Supreme Court from the Court of Appeal in 2018. She was judge in charge, head of international judicial relations for England and Wales from 2005 until 2018. Is a member of the Permanent Court of Arbitration and an ad hoc judge of the European Court of Human Rights in Strasbourg. And Lady Arden's also written extensively on how the law keeps pace with social change. So Lady Hale, Dame Rosalyn, Lady Arden, thank you very much indeed for agreeing to take part in this panel. So I'd like to start off by asking Lady Hale a question about being the first woman law lord and Supreme Court Justice in the United Kingdom. What were the main challenges that you faced?
Well, if I start with the challenges of being a law lord, I became a law lord in 2004. And I recently learnt by reading the diaries of fellow law lord Lord Hope that there were to be 3 new law lords starting in January 2004. And he said this about us. He said, Simon Brown will bring his usual good humour to the Law Lords corridor. Bob Carswell will easily fit into Brian Hutton's shoes as our man from Northern Ireland. And Brenda will be a source of some anxiety until we have got used to the very different contribution she will make. Now, I was blissfully unaware that I was causing anybody any anxiety. So it's a credit to my fellow law lords that I was. But of course, with every first woman new job that you get, and we've all had a few, some of us at least, and I'm definitely one of them, suffer from imposter syndrome. You think, what on earth am I doing here? How can I possibly actually work alongside these great giant brains in the Law Lords? Am I up to the job? And it takes a little while before you discover that, yes, indeed, you are up to the job, but other people have to tell you that. So I think those are the main challenges, and those are the same challenges that I felt when I became a law commissioner, because again, that was a big change from being an academic lawyer. Loved teaching students, loved writing stuff. I've done a lot of writing in my life. And the only thing I didn't like about being an academic lawyer was examining. It's far and away the worst thing that any academic has to do.
Yes.
But the one thing it does teach you is how to be decisive, because you have to be, and how to be decisive in conditions of considerable stress. That's a very good preparation for being a judge. And people don't realise that about academics. Anyway, but I did have the same imposter syndrome when I went to the Law Commission, but I did eventually find out that, yes, I could probably do it. And so that's always the answer when you suffer from imposter syndrome. Somebody else thinks you can do it, so of course you can do it. So those are the challenges.
Do you think the same challenges for women in the legal profession more generally in the United Kingdom?
Well, the most difficult challenge now for women is there are no more first women jobs available. Our generation has pinched them all. Actually, that's not entirely true. There are still a few. And I say that in all modesty. In our generation, it was easy to be the first woman because there hadn't been any others. And so it's something that is of limited credit, I think. Women these days have no difficulty getting into university to read law, whereas, of course, we all had great difficulty getting into Girton to read law because there were 3 women's colleges and 21 men's colleges. I could say a few things about that, but of course the one thing it did teach you was that you were better than quite a lot of the men. That was a very useful thing to be taught. But there was also a big challenge getting into chambers. I'm sure Mary will be able to talk about that in particular. Chancery chambers was not something that was very welcoming to women. I had not a lot of trouble getting into common law chambers in Manchester. I was the second woman in those chambers. I always feel grateful to the first woman. I've been the second woman as often as I've been the first, and I'm always eternally grateful to the first. But these days, those are not the challenges that the women face. The challenges the women face are the pressures of life in independent practice. And this is almost worse in certain firms of solicitors than it is at the bar. But the challenges are obviously the 24/7 working culture that there is. In solicitors' firms, it arises quite a lot out of globalization, which makes it necessary for the firms to be on call most of the time. So these are pressures which it is very difficult to combine with a normal life, whether it's family life, whether it's family responsibilities, or just life. A lot of men feel exactly the same, but they don't feel it's as easy to get out and move sideways, whereas a lot of the women, they don't leave some sort of legal practice. Some of them do. Some of them leave for a while and some come back, and the profession is trying to make it easier for people to come back. Yes, easier. And the profession should also be thinking about all of those terrible work-life balance things that they need to address. The professions need to address that. And I think the bar is the solicitors are a bit behind that. And it's very variable with the type of solicitor's practice. But quite a lot of women go into other sorts of legal jobs. So they go into the government legal service. They go into law teaching and academic work. They go into local government. They go into regulation. There are a lot of jobs in regulation these days where they do great work and their brains are very well used. So one of my great campaigns, and I'll finish on this point, one of my great campaigns is for the judicial appointment system to recognise that those are pools in which they should be fishing for judicial appointments just as much as they fish in independent practice. And that would be a way of that would be a way of increasing the diversity of the judiciary, not only on a gender line, probably also on ethnic lines, and certainly on professional background lines, which I think is really important. Sorry, I'll stop talking.
No, thank you very much. That's fascinating. So in the course of answering that question, you have covered some ways in which the challenges may best be met. I mean, moving sideways from working full-time in a law firm, actually having affirmation from others to correct the imposter syndrome, other people having a belief that you can do it, even though initially you might not think that you can do it yourself. Are there any other ways of meeting these challenges that spring to mind, either Lady Hale or Lady Arden or Dame Rosalyn?
Well, I'm already mic'd up. If I may, I'll, in answering your question, pick up on some of the interesting points that Brenda's made. On the imposter syndrome, I absolutely recognise what she was describing. My imposter syndrome started when I came to Girton. I came from a grammar school where there'd hardly been anyone at university and certainly no one at Oxford or Cambridge. So I spent my time before arriving being equally thrilled and anxious, and the first week being equally thrilled and anxious, and then I came to realise, I am going to be able to cope. And then I didn't have that sensation in academia at all. It never occurred. There was not particularly a male-female divide, and I felt I was as capable as others. But certainly I felt duly daunted when I went to the International Court of Justice. And of course, your children are great, aren't they, for keeping your feet on the ground. So the first day when you're introduced by the president at the appropriate session in the International Court of Justice, he makes a speech about you and your family are there. It's a very celebratory day. And just before going to sit on the bench, my daughter had passed me a little bag with a book inside as a present for good luck. And I slipped it out beneath the bench and looked at it. And it was a book entitled How to Bluff Your Way in International Law. So that definitely keeps my feet on the ground. I had an entirely warm welcome from my fellow judges who, well, they may have written such letters, but I don't know about them to this day. I had some lovely letters from some of them. And then once we got down to business, it was simply business. I can't think of a single incident from them where gender was relevant in a remark or conversation. I say from them because I have to admit that once it was from me. Judges at the International Court of Justice have the legal status of ambassadors, which means we had the perks of duty-free cars. And every now and again, the government sends in inquiries about how we're using the cars and the system. And I sat through in my first term such a discussion, sat quietly, didn't say anything. And the president said, well, I do need to be able to reply on behalf of the whole court. Judge Higgins, what do you have to say? And I'm appalled to tell you, I found myself saying, only 14 men would spend this long talking about cars. The only other issue when I arrived was I did have to say, I really do need a separate ladies' loo, please.
I went to a school which was girls only, So it never occurred to me that there was any problem about girls having a career, and I was brought up in a very egalitarian way. My brother and I had equal opportunities, and we were given different opportunities in life. So I came here. I was interviewed by someone whom you may remember, the much lamented Poppy Jolowitz, and she was very inspiring. And she examined me when I came and interviewed me. And then when I was taught here, I was taught by Cherry Hopkins, whom I hope is here, who was a model to us all. And it was very inspiring being in Cambridge. You go to Hall, you see all those wonderful pictures of the Girton pioneers, the fire engines. They're playing games on the games pitch we're sitting on. And so when I came to go into the outside world, I thought, well, the world's our oysters. All the battles have been won. There's nothing else that women need to achieve. We just go into the jobs. Huh? Nothing could have been further from the truth. I went actually and studied for a year in Harvard, which I greatly enjoyed. I came back and I set about finding chambers. I was lucky enough to find a pupillage because the person who asked on my behalf, because you had to have a contact, was able to say to the chambers, please produce your best junior, otherwise we withdraw all our work. And so I was very lucky. I got one of the best pupillages imaginable. When I got into Lincoln's Inn, there were obviously several hundred male barristers. There were only about 2 other women, one of whom I know advised in chambers, puffing a Sherlock Holmes pipe. So it was a very strange environment. I recall that Glanville Williams taught us when we were here in Cambridge. Glanville Williams is one of the great experts on the English criminal law. But he also wrote a book which everybody who was going into the law had to read, called Learning the Law. And in the edition published in 1973, which is 3 years after I had already gone to the bar, he actually wrote that no women should contemplate going to the bar unless they've got someone who could help them, and that fundamentally women were not suited to the bar because they would never give the fight, and they were not interested in fighting in court. And so that wasn't a very good start, but we did our best, and then having done the pupillage, it came to the task of finding a permanent seat in chambers. At that time, although I was very lucky, lots of women got the answer, I'm very sorry. You've got wonderful qualifications, but we've got a woman already. Or we haven't got a ladies' loo. There were other questions, like all the solicitors are male, and we don't think they'd instruct a woman, and so on. But my chambers were lucky, and I was lucky in them, in that they were prepared to give me the chance. The problem for women at the bar was really one of the structure of the profession. Recently, I've been reading a book called Invisible Women, Invisible Figures, which some of you may have looked at, which is about the lack of gender-relevant data in decisions. For instance, when you take out your mobile phone, it's all very well, a man can easily text with it because the size is just appropriate for his hand, but it's not for your hand. That's because they don't model their new products all the time on women. And the piano keyboard, for those of you who play the piano, is just a bit too long for us. The octave is just a bit too long for the stretch of our hands. And it's just the same in the organisation of the bar. There were no women, so why did they have to organise the professional day round women? Women had to be there at 9 o'clock, even if they had small children. And they had to work the entire day and work in the evening, even if they had a sick child. So it wasn't structured for women. And that was the real battle that made it very difficult. And also it's modelled on the adversarial role. The person who speaks up loudest and longest will often win the judge's eye and win a case. So that means that often women don't stay very feminine. They tend to become one of the chaps. And that's another grave weakening of the position of women. So after a few years, I was very lucky. I took silk. That means I became a Queen's Counsel. And so I didn't live up to the expectation that no men would instruct a woman. I was very fortunate indeed. And then in 1993, I had the opportunity to go on the bench. And that was a wonderful occasion too, because I was the first woman to be a member of the Chancery Division, which deals mainly with property disputes. And things are like character, if I can be very brief about it. And that was a wonderful opportunity, and indeed I became the first woman first woman chair of the Law Commission, which was the best job in the judiciary in my view. I can talk about that later. But there was then a question of, there were very few women in the judiciary. Gradually they became more, but there was then the question of whether you could get promotion as a woman. And ultimately, the law was changed in 2005 to allow for a Judicial Appointments Commission, which Lady Hale has referred to. But my experience has often been that it's 2 steps forward and 1 step back. There we had this wonderful commission, which was going to be an independent body to deal with promotion on an egalitarian basis, irrespective of orientation, gender, race, ethnicity, and everything else. But the terms of reference given to the commission simply said that it was to try and get the most diverse pool possible. It had no duty to make the judiciary representative, although that was the first text of the bill that was changed. And so I looked with interest at what happened when this commission was set up. And talking of my 2 steps forward, 1 step back, in the first 3 years it appointed fewer women, can you imagine that, than in the previous 3 years, so that it didn't make the expected progress. And so it went on. There were lots of measures paraded as things that would help women to progress, which actually didn't have that result. One small example, 2009, the Lord Chief Justice organises a conference in the Barbican to discuss judicial diversity because there were so few women judges. It was a huge event, lasted all day, loads of speakers. But who chaired it throughout? The Lord Chief Justice. Who had control of the recommendations? The Lord Chief Justice. And so it was an action which was intended well, but didn't result in much action. So there we are. Anyway, it's all ended up all right, in the sense that there are now, across the higher courts, about 25% women in each of the levels. And that's very good indeed, and I hope it will stay that way, and that diversity of every kind, that means irrespective of training, experience, so you include the government legal department, which has indeed got 1 deputy judge already, and I think maybe more. And
Court of Appeal judge.
Called
Vivian Rose.
Vivian Rose. Well, yes, and I was thinking particularly of somebody who was appointed directly out of the government legal department, from the Attorney General's department. And so we are taking steps forward. More attention is being paid, I think, to ethnicity, and I think that will be the next big step to be made when we get more ethnically diverse judges. So it's been an interesting path to travel, a journey to take, coming out of Girton, where one thought that all the battles had been won by the pioneers, but there were still a few left.
I have something from backwards here.
Dame Rosalyn, would you like to add anything?
Well,
to that?
I'd like to paint the picture at the international level for those last things that Mary's been saying. In academia, it took a long while for there to be women professors in law, but now they're fairly, our gender is fairly well represented, and in law school classes, it's certainly 50-50, if not more women students. I recognize exactly what Brenda has said about solicitors' firms and the problems women face there. When you come to the international scene, you may plead at the international bar. You don't have to be a member of your national bar, but you have to be an international lawyer of standing. So we see there academics who do a lot of practice, and I was like that for a while. I was a full-time academic and a moonlighting practitioner, and all of that works reasonably well. But there are rather few women practicing in international courts as counsel in front of the bar. A very small group. There's no impediment because they have these 2 paths in. but it's only growing incrementally. So far as the bench is concerned, the story is rather different between the different international courts. As you heard, I was the first woman at the most senior court, which is the International Court of Justice. Since the inception of that court, and it's the successor to the Permanent Court of International Justice of the League of Nations, so it's been around for a while. Since its time, there have been new courts and tribunals, mostly in the criminal field. You'll know all about them. The temporary bodies, the International Criminal Tribunal for Yugoslavia and for Rwanda. They've done not badly on having a decent number of women on their bench, but it's certainly still short of parity. And the Rwanda Tribunal has done better than the Yugoslav Tribunal. Now, the International Criminal Court, the permanent standing, non-UN, but inter-treaty court for villains coming to justice, that court has, and one of you mentioned it before, I think it was Mary, a process requirement rather than an outcome requirement. So out of every 9 people coming up for election, there must be X women. It's done that way round. And they do have a very balanced gender bench. So I think at some stage we have to face the very real issue of whether, if you're doing things through mechanisms rather than letting them be achieved through quality, whether you necessarily finish up with the best outcomes.
You've mentioned some ways of addressing the gender imbalance. Is there anything that you think is the most important thing that could be implemented? What do you think would be the most effective measure to redress any imbalance?
Well, at the international level, which is really all I can speak to, there can be quotas. I personally, I was all in favour of positive discrimination for a fixed period in the American college entry system, which I don't think is entirely comparable to people coming through to benches, judicial benches, but there can be quota systems, and I find not the best. People are then promoted by their governments. All the governments want to see is they've got numerically their number of women. So that can be a way, but it's not a way I support. A much more transparent appointment or election system, I think, is really important. The UN tells every time there's an election within the UN family of courts, it tells those who will participate in the voting, usually states, they should remember the importance of non-discrimination, of representational benches, of bringing women forward. The UN gives constant reminders on this. The system must be open, so capable women will know they may apply. Those, in my mind, are the right ways forward.
Thank you. Lady Hale.
Well, I'd like to comment on that. I've always been against quotas because I think they're bad, both the people not appointed and the people appointed. You know, the person appointed, are they going to think that they've only been appointed because, to make up a quota, and that therefore they are imposters, to go back to our previous conversation? And of course, the people who are most likely to think that are actually the people who would always have been appointed.
Yeah.
So it's bad for the people appointed, and of course it's bad for the people not appointed, and it's bad for the system because we're not getting the best people. And what we want are the best people. But that begs all sorts of questions, doesn't it? You know, who are the best people, and how do we define them, how do we assess them, and how do we flush them out from wherever they happen to be in the system? And those are the challenges, and they are the challenges that the Judicial Appointments Commissions in the United Kingdom are facing. But I have to say, I do think they are doing their best to resolve them. Over the last 10 years, we have made enormous progress in the number of, in the gender diversity of the judiciary in England and Wales, and I think the same is true in Scotland, less true in Northern Ireland, which has its own particular difficulties anyway. And the processes that they're involved in are, of course, open and transparent. You have to apply. You have to fill in an application form or write a letter of application, measuring yourself against, oh, I do hate the word, competencies. With an I. No. Competencies. But anyway, you have to do that. You have to, for the Supreme Court, you have to submit 3 pieces of written work to be marked by the commission that does the appointment, and you have to submit references, and there are consultations, and so on. So it is an open and transparent, and there are interviews, process, and I think that is the best way to try and find people. Obviously, international tribunals have got a different process, and one understands why they do, because these are decisions by states. But for the UK, this has had a transformative effect and is continuing to have a transformative effect on the UK judiciary. And I was told by the senior president of tribunals not very long ago that now the gender and ethnic balance of the tribunals judiciary roughly mirrors the gender and ethnic balance of the working population of the relevant ages, which is brilliant. They have achieved it, he tells me, by not insisting that everybody's got litigation experience. And that's the major barrier, because if those assessing people's merit think that advocacy experience or litigation experience, not the same thing, is essential as a qualification, that is going to rule out a great many of the very, very competent women whom there are about in the system. So that's the sort of problem that there is. But no, let's not have quotas.
Would you like to?
Yes, I'd like to say that I absolutely agree with every word of Lady Hale's answer. Could I just focus on 2 points? First, the word merit, and we're both saying that merit has to be the overriding feature, is the most contested concept and needs a lot of time to unpack. But moving back from there, just in case we all go away saying, job done, this is all nice and everything's been done for women in the judiciary. The judiciary obviously takes women from the professions or from other legal posts, but mainly the professions. The bar has an inbuilt progression stage when women take silk. The number of women applying for and obtaining silk is still not very high. And that's a worrying feature for the future. For instance, Lord Chief Justice of Northern Ireland told me that they've just had a silk competition in which there were 31 applicants, of which only 7 were women. That's a very low percentage. And it is worrying for the future diversity of the judiciary that should be low. That figure should be low. And so I just sound a note of caution. Can I just say that I also agree with very much of which has been said, but there's one further point. I think the real difficulty for women is transitioning back into their professional jobs or in their jobs in the law after they've had time out to look after their children. It's very, very difficult. It really challenges the imposter concept, because you think to yourself, I've lost all that time, the law's moved on, can I really do it? People have got ahead of me. Can I get back in? What sort of firm could I choose? Will Chambers have me? I'll be out of the age order in Chambers. It's very worrying. And there, I think we could focus more on trying to help women in that position, trying to coach them as to the possibilities, giving them some mentors, and giving them also some role models of people who've done it, so that it's a little bit easier. I see it in the next generation. Women are having a much tougher time bringing up children than we had, because we were able to have nannies who lived in and were there in the evenings if we were home late. They're taking their children to nurseries. They've got to be back on time. They've got to get them there on time. They haven't got the houses now which enable them to have anybody living in. Thank you.
That's true.
Lady Hale, do you think that being a woman influences the way in which you interpret the law? And if so, how?
Well, sometimes. Not often, but sometimes. Because one of the arguments for greater diversity, I mean, there are lots of arguments for it, including legitimacy and how things look and feel to the people in court and to the general public. But one of the arguments is that a diversity of experience of life can sometimes be relevant in the cases that you have to judge. And most of the time it isn't, but there are some where it is. The best example I can think of, leaving aside the obvious ones like wrongful conception, where clearly women have a rather different take on the consequences of wrongful conception from the take that men have. But the one I'm most proud of is where we recognised that the concept of violence was a wider concept than just being hit or being threatened with being hit. Because there are many other ways and many other threats that can be used to keep somebody under control. And we recognised that in the Supreme Court, unanimous decision of the Supreme Court, I'm equally proud of that, in 2012. And we said it had also been recognised by a law commission prompted reform of the law in 1996. The rest of the legal world is taking a bit of time to catch up with that, but they are beginning to do so because it's beginning to filter into the criminal courts as well. And that was something that I think empathy with the situation of women. I remember a cleaner in the University of Manchester. The charge hand came to me and said, "Can you have a word with this woman? Her husband is beating her up. She's terrified of him. She doesn't know how to escape, etc., etc." So she did come along to see me. And it wasn't so much the beating up that was keeping her there. It was that her husband had convinced her that if she left him, she'd lose her children. He had convinced her of that, and that was what was stopping her actually doing anything about it. This is a long time ago now, but it's that sort of experience that you can bring to working out what concepts mean, which just occasionally does make a difference. So yes, I think it does.
Dame Rosalyn?
I have a slightly different take on it, always from the international experience. I feel that on the sort of issues that Brenda has raised, wrongful conception, beatings up and so on, undue influence, even beyond the use of force, I think decent men have the same sensibilities about that as women. That may be an old-fashioned view, but it's what I believe and what I have experienced. I've found in practice that it's so often not the genres you expect, whether gender ones or nationality ones, who will have particular views on this or that, but just sympathetic people from each of these pools who find they have much in common. So there's a slight difference of perception, perhaps, there. Of course, in my sort of work, these issues or ones very similar to them, arise in the international criminal courts, where issues about rape as a war crime, the sort of sentencing there should be for sexual violence in hostilities, do come up. I know my colleagues from these courts, I have personally not found different gender perceptions on sentencing these issues. But in my court, which is an interstate court, where we were dealing with such issues as a territorial title, whose land was it, whose seas was it, was there a use of force across a border? I tell you, if you're looking at a strip of sand, it looks the same to a woman as to a man. So the issue doesn't arise very clearly for the International Court of Justice. If I can add just a couple of words, there are, of course, as all my friends here know, other issues that are commonly referred to as being important for parity on a bench, so far as gender is concerned. One, which was just mentioned by Brenda, is representational, so the people out there should feel this is a court that represents them. I'm not sure really that applies in an international court either. These are states out there sitting in front of the bench, and still the preponderance of foreign offices will be men, and they're not going to feel that the decision is any better or worse through having an equal number of women on the bench. We've talked about, do women think or decide differently? And the third one that is much talked about is the human rights element. Article 8 of the UN Charter says there shall be no impediment to equality of women in any UN positions. That's, of course, put negatively. But by the time you arrive at the International Treaty on Women's Rights, it's put positively that methods are to be found to ensure that women are indeed treated comparably.
Could I just make one remark? Because I of course agree with you about men of goodwill. And equally, of course, there are some women who aren't of goodwill.
Indeed.
The really important thing is whether people are feminists or not, i.e. genuinely believing in the equality of women. And you can have plenty of male feminists and plenty of female non-feminists. Yeah. We have to just face that fact. Yeah.
Do you want to add anything, Mary?
Yes, I do. Much of my work does not concern individuals, because I deal with property and companies and all sorts of things like that. But there are occasions, as Brenda has said, where being a woman matters. And I had one case where, a very sad case, where a woman had to have her ovaries removed because of cancer. But she had had IVF before that happened, and the eggs had been fertilized by her then boyfriend. She later wanted to have children, she could still have children, wanted to use the fertilized eggs, but her boyfriend refused, and there was a question whether she could still have access to them, even if he refused. And I was sitting in the Court of Appeal, so there was a bench of 3, 2 men, 1 woman, and the 2 men were very anxious that I should write a judgment jointly with them. And I said, no, I think I should give the woman's point of view about this. It's a very, very sad event for a woman not to be able to have access to her the last remaining possibility of having her biological children. And the case ultimately went to Strasbourg. It was a very important case in determining rights in following on from IVF. But I wanted to say that this is where the book about invisible figures comes in again. The book explores all this data out there which has been compiled simply by using one gender. And it shows how it can work to the disadvantage of women. For instance, some drugs are trialled purely on data from men, and they turn out to be unsuitable for women. So the point it's making is it's very important that women are in there, that they are visible, that they're involved in the decision-making, to point up the different impact which different rules can have, in the case of the lawyers anyway, the different impact the rules can have on women. And that's what I take away, is that we really do want more women present in the judiciary in order to make sure that the special position of women, if there is one, is known about and can be taken into account.
Thank you. There is some time remaining. I'm conscious that there may be some questions from the floor, so I'd like to invite questions from the floor now, please. Yes, here. The woman in the second row.
Ask
Yep.
them to give their names.
Could you give your name, please?
Maureen McLashan, another Girton lawyer, and another person who's been the first woman to do several things, and that time has passed. Because if you've been the first, nobody else can be the first. My comment, my question is very short. This is the third session I've come to this morning. All of them really seriously interesting. I would actually like to carry on the discussion from each of those sessions in another context, because I was so interested. What has struck me is that out of the 9 or 10 questions that have been asked at those 2 preceding sessions, 6 of them have been asked by men. And I wonder what this actually says about why we're not getting the obvious equality that we would like to see in the professions that we've been talking about. I find it extraordinary that in this context, the men are making the running.
But is that because of the unwillingness of the women to put their hands up, as you very quickly did?
Yes.
Or is it because of the choice made by the person choosing
No.
the questionnaire?
It's nothing. I mean, my question really is quite a serious one.
It is one.
What is it? And it fits into a certain extent, I think, with what you called the representation issue. How good a lot of job opportunities, let's call it that, are actually dependent on people who've made their conspicuous mark, a representational mark. They've got to be seen, making that imprint somehow. And I wonder if that's something, not because women aren't capable and in a quiet sort of underlying kind of way, as good, every bit as good as the men at doing it, but that fewer women are willing, able, constitutionally made that way, actually to take every opportunity to be making their mark. If they think that they're an imposter, that you're at a meeting like this, that they're not quite good enough to be asking the question, they may be making a fool of themselves, they won't ask the question, is it that fewer men mind about making the fools of themselves?
Could be right about that. Yes.
I think Mary might like to say something on that.
Yes, I just want to give a very serious answer. I think there is plenty of research to back up what you're saying, that women will not speak up as much as men, and that they will be interrupted much more if they do. We all know this cartoon of the men sitting around the board table with one woman, and she makes a proposal, and the chairman says, thank you very much, Miss Smith. We'll wait to see if any of the men make the same proposal. Or they only talk about it when the man has repeated the question, and then he gets all the glory for it. But there are things that can be done at work to stop this. Some employers have a no interruption policy, i.e., if they have a meeting of the staff in order to discuss a project, everybody will be given a fair opportunity to talk. And I think as women, we have to talk up and say, yes, please can we have some kind of adjustment of this kind to help us?
No.
I'm a bit nervous now about inviting questions from the men in the audience. Perhaps I could take the woman on the third row and then the gentleman in the blue shirt behind. So, thank you.
I couldn't agree more with the previous questioner. Now, it's one thing, we, as women, we have not got enough self-esteem. And that goes through all the professions. I am a vet, and when I turned up in large animal practice, the farmers looked at me and said, "Are you the woman from Mars?" But one battled through. And once you got through, you got away with a lot more. Now, the other thing is, the men do a lot of networking. Now, this is where we do not do enough. A lot of things are carried out in the evening at the bar. And I don't mean the legal bar, I mean at the drink bar. And here we fail to network, not only with other women, also with our male colleagues. And I think this is something we must work on.
Well said.
Yeah.
I'm sorry, I forgot to ask, could you just give your name, please? Thank you.
I entirely agree with that. I will be very short. We have to think of strategies to cope with that, because we can't, if we've got small children anyway, go out to the bar in the evenings. One of the methods, which has just been introduced in some places, I think is very good, and I'll mention two of the points. But the first is reverse mentoring, i.e., you don't just have mentoring where the senior person mentors the junior, but the junior has space to go and talk to the senior person, and that they can learn about the job in its higher reaches and therefore prepare themselves going up in the business or the profession. And secondly, it makes sure that they are known about by the senior person. My second proposal is this, and Girton could take a leaf out of this book. In some offices, you go in and you'll see a long row of photo portraits of the past chairs or CEOs or the heads of chambers, wherever you are, or the senior partners. Now, what you can do is take one of those off the wall, or better still, just move them out of the way, and put a blank mirror in there, frame with a blank mirror, and tell every woman, if she works hard, she could be the person who has her portrait up there.
Yeah, that's nice.
Mirror project.
Yeah.
Try it.
Yeah, good idea. Yeah.
Gentleman in the blue shirt, if you could
Yeah,
just give your name, please.
my name is Harry Dealman, husband of a very capable Girtonian, and I've got a question about corruption. Being South African, living currently in Thailand, we used to live in Argentina and in Italy. Perhaps enough said about corruption from my side of it. Have you found, what I believe is the truth, that women are significantly less inclined to be corrupt, either at petty levels or even at big levels, than men?
Lady Hale?
Well, we like to think, of course, that in this country, the judiciary is totally and completely incorruptible, and everybody believes that. There's actually some European evidence to support that we may not be wrong about that. But I do recall talking to a Nigerian contemporary of my husband's at University College London, who then was head of the law school in Nigeria. And he said they like women judges in Nigeria because they are not subject to, he did use the word corruption, but what he meant was the family pressures,
Yes.
the pressures to do right by your people, which are very common throughout the world. And the women didn't have the obligations to look after their people, so they could just get on with the job. And I thought that was very instructive, and he was probably right about it because he was talking about his own country, and I can see that Dame Rosalyn is agreeing with that. That sort of pressure is not so common in Western Europe, but there are other sorts of pressure that are. And I think all the members of the judiciary, senior judiciary in England and Wales at least, have undergone unconscious bias training, because we all suffer from unconscious bias, and the problem with it is that you're unconscious of it. So the only thing that can happen to you is that you are taught that you do have unconscious biases and how to look out for them. And that's a more insidious and more difficult problem, and I don't think women are any less subject to it than men are. They're just likely to have slightly different unconscious biases.
I agree with what has just been said. There's obviously a close relationship between corruption, properly so called, and exposure to political influence, not necessarily monetary gain, but political influence creeping into judicial decision-making. Both could be a problem for an international court, and the judges there are appointed not by their governments. Their nomination will have gone through different processes and checked out along the line by senior law officers who will have declared there's nothing on file against that person, but it's normally independent groups, and Mary is part of our present one, who make the real decision there. So that's not the problem. The problem is that, first of all, of course you know that in certain cases, particularly if your country is appearing before the court, how fearfully important the outcome is for your country, and you can well understand those arguments. And it does require a certain toughness of character to decide absolutely without regard to that on the basis of the law as you see it. The other element is that judges from certain countries are not as fortunate as we are. When I was on a different quasi-judicial body, the Human Rights Committee, where I was appointed by government, at that time John Major was our Prime Minister, and we were looking after cases under the UN Covenant on Civil and Political Rights. My term came to an end. It was time for re-election if I and the government wanted it. And all my colleagues came to say goodbye to me. And I said, but I really hope I'm staying. And they said, yes, but Tony Blair's now in office. And I said, in our system, that's not going to make any difference at all. And there was a great deal of nudge, wink, wink, we know really it will. Well, of course, it didn't, and I was returned again. And I think we don't realize how blessed we are to be living, whether we finish up internationally or stay abroad, in political pressures being so minuscule on the judiciary in this country. I always remember it was Margaret Thatcher who appointed Stephen Sedley.
Yeah, but a Conservative government made 4 of the most adventurous High Court appointments.
Yes.
Well, Stephen Sedley was one of them.
Yep.
The first solicitor High Court judge was another of them. Me was another courageous one to do, because I came from a different background. And of course, the first woman in the Chancery Division, the first woman in the Queen's Bench Division. That was all under Lord Mackay of Clashfern.
Yep.
One of our honorary fellows. Yeah. Can I just say something? In my career, I've done a lot of international work, and I think possibly I have a particular interest in international work because I come from the great port of Liverpool, which was very, very diverse, and it enabled me to see people coming from abroad and take in the very different ways of life that there are in the world. But I want specifically to say about South Africa, I've no experience of corruption anywhere in the judiciary, but I know that in South Africa there have been 1 or 2 cases of scandals about the judiciary. But the Constitutional Court of South Africa is a beacon to us all. It's one of the most respected institutions, as I understand it, in South Africa. It has repeatedly upheld the rule of law and is a great model in that regard for what it has done. And the same is true of very many members of the judiciary in South Africa. So I didn't want anyone here to run away with the view that we thought that they were corrupt.
No.
Unfortunately, we've reached the end of our time. It's been an absolutely fascinating discussion. Thank you very, very much indeed again to Dame Rosalyn, Lady Hale and Lady Arden. If we could show our appreciation in the usual manner.
Thank you very much. Thank you.
Thank you very much. You're free to grab some lunch now.